I'd like to mention hearing item number 5.
Mhm.
If this matter can come up after a few weeks.
I don't think I can take up this matter also because he is my cousin. Yes. Item 5. Okay. This matter before any other bench without me. Put up after 3 weeks.
3 weeks.
After 3 weeks.
Bless you.
For motion from the supplementary cost list, item number 7. Please, Ladyship.
Yes.
Leadership, in this case, this is an application for quashing the FIR in charge sheet. The FIR is at page 19.
19.
Yes. Type copy can be seen at page 22.
Okay. Yes.
Here we go. To the officer in charge, Kuboto Outpost Newland, subject FIR. Sir, with reference to the subjected cited above, we, the Lotovi Village Council, are obliged to bring forth grievance to your esteemed office that Sir Mr. Salman, son of Chora, a resident of our village, has been kidnapped by 4 unknown miscreants who happened to come from White Alto car around 4 to 5 p.m. on 12th August 2024. And to our utmost shock, the miscreants had demanded an amount of ransom of rupees 2 lakhs, which is to be delivered at Vihoko Junction at 8 a.m. that is 13/8/2024. The village council therefore requests your interference to this matter as early as possible. Lordship, in this case, the allegation is of a kidnapping. What happened in this case is that there are 3 accused persons, 3 petitioners in this case. The accused number 3, petition number 3, and the alleged victim in this case are relatives. In this case,
Accused petitioner number 3 and
alleged
The
victim.
victim.
Yes,
Okay.
they are relatives.
Mm.
The alleged petition number 3 had advanced an amount of rupees 2 lakhs on different occasions
Mm.
to the alleged victim.
Mm.
And then the petition number 3, on different occasions, he had requested the alleged victim to return back the money. But then since the alleged victim did not return back the money, the petition number 3 had sent his friends, that is petition number 1, to go and bring the alleged victim to his place to sort out the matter. And on 12th of August 2024, the petition number 1 and 2 went to the place of the alleged victim. And then he was taken to the petition number 3 house to settle the issue. Meanwhile, the parents were unaware of the financial transaction that has been going on between the alleged victim and the petition number 3. And thereafter, the alleged victim parents went to the village council chairman to notify of the incident that has happened.
And lodge this
Yes.
complaint.
And so the council chairman has lodged this FIR on the family's behalf. Now, soon after they were apprehended on 13th of August 2024.
They're coming on the basis of this
Compromise.
HRC.
Yes.
Compromise
Lordship. Soon after the arrest, the family members of the alleged victim, the petitioner's family, they all went at the council chairman's residence in the presence of the alleged victim and his family members. And after thorough deliberation on matter, they have decided to settle the matter.
Yeah,
And
we'll
then-
have to issue notice on the respondent too.
2 and 3.
Respondent.
I have it, yes.
Yes, 2 and 3.
Yes. So based on this compromise deed only, I am filing this application for quashing.
Third Learner Counsel for the petitioner, Shri V. Achumi.
Vinokachu.
Vinoka Achumi. This is an application under section 528 of the BNSS for quashing of FIR number 24/2024 dated 13/8/2024 and charge sheet number 11 of 2024 dated 27/8/2024, which was registered as Newland PS case number 24 of 2024 in connection with GR number 414 of 2024 under section 140 under bracket 2/3 under bracket 5 BNS. So the petition is filed on the ground that the accused persons and the victim have entered into a compromise, being relatives, and have executed a compromise deed dated 24th August 2024. And hence the present application praying for quashing and setting aside of the aforementioned FIR, and the charge sheet. Stop. Next paragraph. Learned PP MS Mary has accepted notice on behalf of respondent number 1. Stop. Issue notice on the respondents number 2 and 3, returnable within 4 weeks, the petitioner shall take steps for service by registered post with AD.
Lordship, I may also be allowed to take dusty service.
Okay. Registered post as well as dusty service.
My lord, I also have an interim period,
Lordship,
which is there for.
interim may be considered on the next date, because your lordship, here the charges levied against the accused are non-compoundable, your lordship, and ground of compromise is not permissible under the law.
That's why we have to hear
Even-
the
yes,
other
yes.
party first. Notice only on the next day, the prayer for interim relief
Lordship,
shall be
here
considered.
LCR may be called, your lordship, because it's
Okay.
already
And call for the LCR, scan copies of LCR from the court of CJM.
Principal District and Session Judge Dimapur.
Oh, yes, yes. From the court of Principal District and Session Judge Dimapur.
Applies to the mediation.
For admission, item number 1.
My lord, my apologies. Apparently there are two cost lists, and then a new revise has been uploaded. Actually, it should be item number 6. MSc appeal.
Okay, your
6.
matter, MSc.
Yes, matter.
Okay, okay. That first one, na hearing, that should be item 6,
Yes.
not item 5.
Much obliged.
This is my lordship. My lordship, I filed a consent petition.
1 minute. Admission 1, yeah, okay.
No, this is my lordship.
Yes.
My lordship, I have filed this instant application challenging the impugned summoning order dated 29/9/2023, passed by the learned CGM parent, my lordship. So my lordship, in this case, a CR case was filed by the respondent complainant, my lordship, under section 138 of the NIA, my lordship. So my lordship, the petitioner number 1 herein is the firm, my lordship, and petitioner number 2 and 3 are the partners, my lordship. And as per on perusal of the complaint filed by the respondent, my lordship, they have filed under section 142. So since the petitioner is the firm,
142 NIA.
my lordship,
Mm.
since the petitioners are firms and partners, my lordship, they should have filed under section 141 of the NIA, my lordship. That is the offense by the company, my lordship. So, my lordship, in this case, a legal notice was issued by the complainant to the petitioner, my lordship. But the same was not served, my lordship. And with
Legal notice was not served.
no, my lordship. So I have enclosed that document also, my lordship. That is on page number 127. They have served 3 legal notice, my lordship, but the same were returned.
127.
Yes, my lordship. 127 pertinence to petitioner number 1, my lordship. Dated 14/6/2023, my lordship. And the note has been mentioned, not delivered, address removed. And regarding petition number 2, that is page number 129, my lordship.
Page 124 is petitioner 1.
Yes.
Page
And regarding petitioner number 2, my lordship, that is page number 129.
129. Yes, petition.
Dated 5/6/2023, my lordship, not delivered, no such person in the address. And regarding petitioner number 3, my lordship,
Yes.
that is page number 132. That is item returned insufficient address, my lordship. So, my lordship, in this case, without serving legal notice to the petitioner, the learned court below took cognizance and issued summon to the accused person on 29/9/2023, my lordship. And my lordship, similar to this case, the complainant has filed 2 cases before the learned court below, my lordship. This case is pertinent to CR number 3, my lordship, and another case was filed by the complainant again. The fact of the case were same, the complainant were same, the accused were same, the court was same, my lordship. And I have the order copy also. In that regard, we raise an objection regarding the service of the notice, my lordship. So in that regard, we filed a revision before this honorable court, and this honorable court passed a direction to the accused, to the complainant, my lordship, regarding issuance of the notice, my lordship. Though it has been
Same parties.
same party, my lordship, same party, same court, and the learned court below, in a mechanical manner, he have passed a summoning order in both the cases, my lordship. And in this case also,
Inquiry under 202 CRPC was done.
yes, it was done. but without considering whether the service was served or not. The delivery note, it has been mentioned that the address is moved, and in other part, due to insufficient, the notice is unable to serve. But in spite of that, the delivery, the envelope was returned to the complainant, my lordship. They could have filed the envelope, return envelope before the magistrate. That was not done in this case, my lordship. So, my lordship, in other revision, my lordship passed by this honorable court, my lordship. Two questions were arises in this case. In that case also, same fact of the case is same. Only the engagement date is different. Only the checks are different. But the fact of the case is same, and the circumstances aroses is also same. So, my lordship, in this case, this honorable court raised two questions, my lordship.
Para 11.
My lordship, if I may, my lordship.
Yes.
In para 11, upon hearing the learned counsel for the parties and on perusal of the materials on record, two questions arises before this court, my lordship. Number one, whether the learned trial court was justified in issuance of the process in view of the categorical statement made in paragraph number 17 and 14, 17 of the complaint. And most interestingly, my lordship, in that case, in that complaint, my lordship, they have mentioned in their complaint that due to insufficient address, they could not serve the notice. They mentioned. But in this case, in CR3, my lordship, in nowhere in the complaint they have mentioned that due to insufficient address, the service notice could not be served. That is not mentioned anywhere. They have avoided, they have curtailed the truth before the learned court below also. They have mentioned in this case, they have mentioned in their complaint, in complaint para 17 and para 14 of the evidence of affidavit, to without perusing the envelope in question. If the envelope was returned, they could have filed that the service was the service of the notice were delivered at the address mentioned, but no envelope has been envelope in question was annexed in the trial court, my lordship. And number two, whether the learned trial court has exercised the power under section 202 in manner envisaged under law. Do question where arise, my lordship, and the relevant portion. A lengthy discussion was discussed by this honorable court on this earlier case also, my lordship. In para, I'll just read the relevant portion, my lord. In para 16, my lordship, that's page number 12, from page number 12.
Yes.
So in para 16, this court further find it also relevant to take note of that the Supreme Court had in the case of C.C. Alavi Haji was dealing with the aspect of the service of the notice, where the service could not be met on account of being fraudulently refused by unscrupulously means, meaning thereby the question of there being manipulation in the endorsement as regards the availability of the addressee for delivery of this notice. But our case was different, my lordship. Our case was this court, however, finds it relevant from the postal tract consignment, which were a part of the complaint as well as the categorical statement made in so and so of the affidavit, that the instant case do not fall within the ambit of the notice being refused or being person not being available in the house, or the house is locked, or the shop is closed, or the addressee is not in station for which the service could have presumed. Our case is different, my lordship. Our case is the addressee was moved due to insufficient.
Service would not be affected.
Yes, our ambit, because already this court, this honorable court has come to the conclusion that our case do not fall within the ambit of the notice, either being refused or the person not available in the house, or the house is locked, or the shop is closed, or the addressee is not in station, for which the service could have been presumed. We cannot be presumed. In this case, our service of the notice cannot be presumed. It is being an admitted fact in para so and so of the evidence, as well as the so and so, that on account of the inaccurate particulars being furnished, the service of the notice could not be affected. The question therefore arises as to whether the envelope, which admittedly was returned to the complainant by the postal department, contained the same address of the petitioner number 1. Surprisingly, the said envelope was not a part of the complaint on the list of the document placed by the complainant during the time of initial deposition, my lordship. Under such circumstances from the materials on record, it revealed that the learned trial court, while passing an order dated so and so, in that case also, on this date, the impugn summoning order was passed against the accused. For issuance of the process did not take into consideration, my lordship. So therefore, the said order by which the process was issued on so and so appeared to suffer from non-application of mine. The second issue, my lordship, in opinion of this court, is intrinsically linked with the first issue, that is, as regard the compliance of section 202 of the court. More particularly when the accused person are resident outside the jurisdiction of the court. From the fact delineated above, it transpired that the complaint was taken on 17/4/2023, but on the said day, the learned court did not take steps, anything. This is about the process, my lordship. So, my lordship, in this case, the learned, this honorable court passed a direction. If I may, in para 18, my lordship. Para 18, my lordship. It is a well-settled principle of law that the enquiry which is required to be done under section so and so is very important step in putting the criminal process into motion, my lordship. As such, section 202 is necessary safeguard against unnecessary and abusive criminal proceeding being initiated. It's an abuse of law. So before issuing the process, my lordship, the court should have taken consideration the evidence placed on record, my lordship. But that was not done in our case, my lordship. Therefore, while conducting an inquiry under section 202, the learned court is required to apply its mind. The court is required to apply its mind to the materials on record, including the initial deposition, and thereupon either make inquiry by itself or send the matter for investigation. The settled principle of law clearly show that requirement of section 2021 of the criminal is mandatory, my lordship. It's very much. Now, reverting to the fact, it will reveal that the learned court below has exercised its power in terms of so and so in the most mechanical manner. And the same is writ large from the fact from the learned trial court seems to have not at all taken into consideration the content of para 17 of the complaint and para 14 of the evidence on affidavit. In that case, they have mentioned that due to insufficient address, the service could not be furnished. But in their complaint, they have not mentioned in their complaint key service could not be furnished or nothing like that. The truth has been curtailed. So in this case, my lordship, this honorable court directed the complainant. That is last, my lordship. The fact discerned, page number 15, my lordship. The fact discerned herein shows that the address of the petitioner number 1 and the address of the noticee number 1 in the notice dated so and so is the same. In my case, in this case also same. The petitioner number 1 address is same. Therefore, as this court has interfered, not quashed the complaint, the correspondent complainant herein would be liberty to file additional documents. There was a direction to file an additional documents, my lordship, to satisfy that the notice was sent to the address mentioned in the notice that is so and so, my lordship. In as so far the petitioner number 1 is concerned. So, but till that, my lordship, this order was passed 1 year back, my lordship, on 13/12. Till that, this order has not been complied by the respondent, my lordship. There was a direction.
Trial court record has come or not? We'll have to call for the records.
My lord.
Yes, yes. Where's the impugned order anyway?
Impugned order, I've annexed, that is the next one, page number 86, my lordship.
86.
Yes.
Complaint is present. The court says due inquiry was made under
my
section
lordship.
2021. So we'll have to see the records,
My
whether
lordship.
due inquiry has been.
And the initial deposition was done,
Mm.
but at the time of initial deposition, the return envelope was not annexed to ascertain that the service has been met.
Mm, mm.
That is the question. Therefore, we are.
And we have to see the complaint
lordship,
also,
my
the
lordship.
complaint also. Learned counsel,
A Messen, my lordship.
A.
Messen.
Messen, for the petitioner. Sri Mua Jamir appears for the respondent. Respondent number.
Sole respondent.
Sole respondent. So, it appears that the trial court records have not reached. Accordingly, the registry is directed to call for the scan copy of the trial court records from the Court of Learned
CGM parent.
CGM parent. And thereafter list the matter after 3 weeks.
My lordship.
After
My
3
lordship,
weeks.
in the meantime, interim order is there. That may be continued.
Yes, yes. After 3 weeks, stop. The interim order passed earlier shall continue till the next date. List after 3 weeks.
And your advice, please.
I'll keep this in the record or you take it back.
It's okay, my lordship.
Point mission, item number 2.
May I please, Your Lordship? Lordship,
1 minute. Yes, this is for compliance.
yes, Lordship. By order dated 24/2/25, Your Lordship has given a direction.
Mua,
Lordship, I was not paid as of date. As
Not
of date, I
paid.
was not paid. Not paid, Lordship.
what happened?
Lordship, this is the same of-
You have received a partial amount, isn't it?
Not yet, not yet. No. I have refused
Nothing.
to accept that. And they have
Oh,
not
you
offered me,
refused to
Lordship.
accept that 80 lakhs.
Yes.
Yes.
If
Total-
that is the case, Lordship can give a direction to let them deposit in the court.
Total is 177.54.
Lordship.
Lordship, we can
Ye-
see
yes.
page 11 of the state contract. Page 11, last page.
What are you saying? Page 11.
We have offered 80 lakhs out of 177. It is with the executive
You
engineer,
marked an amount
no
of
clerk,
18
but
lakhs.
he is not accepting that. Now,
He
the
wants
remaining
the full
97.
amount.
The
So
remaining
remaining is
97.
97.54.
The remaining 97
Mm.
well, it has to be granted under additionality. Now, this morning I have information that it is still with the Chief Minister's office.
Which department is this?
This MPWD, Your Lordship.
PWD. So you give a definite time till when you can release the remaining?
Otherwise, all procedures are followed. Finance concurrence was
Yes.
taken, everything was done, but now it
You're
is-
only
since-
awaiting the release.
Since the Chief Minister is in charge of the finance also,
Mm.
the has to be taken. That is the only.
So,
Otherwise,
1 month, 1
we're
month,
already, we are already paying 80,000, 80 lakhs.
80 lakhs.
So for that remaining.
You don't want to accept that 80 lakhs?
Lordship, factually, there is no official letter I have received that or they have offered me. It is only our senior government advocate is
It is there in
submitting.
the affidavit.
Yes. So
Yes, there-
Lordship, I was never being offered. What I pray before the Lordship is that if they are willing to pay 80 lakh, let them deposit in the registry of this court. And the balance, let them comply within 1 month, Lordship. If that can be done, Lordship.
You call him and pay him that 80.
80,
Yeah.
if it's
Let the
accepted.
EE call.
No, no,
Yes.
yes, I will pay.
Yes.
I'm willing to pay.
And the rest after a
Yes.
month, within a month.
Yes, 4 months. Allow me 4 months for that 97.
4
For the-
months.
1 month for that 97.
For 1 month for this 97 and 0.54, and this 80, immediately let the EE summon the petitioner and pay, give him. Third Learned Council for the
My
petition.
prayer to your lordship will be if a direction may be given to the department to deposit the that earmark, they have said earmark, that 80 lakhs before the registry of this court.
No, it's okay. You go to the EE concerned. The EE concerned will pay you.
Give a direction strictly, your lordship.
Yes, yes.
It is with the executive engineer and o'clock.
Lordship, can it be fixed on 5th of May?
No, they're asking for 1 month.
Because lordship, on 17, I'm flying for my Mecca trip, pilgrimage. 17th of May. I have the ticket also.
Then we'll fix it on 16th.
Lordship, it will be
But when will you
17th.
come back? When will you come back?
Lordship, 3rd July.
3rd July. So even if you're not there, your petitioner will be there, no problem.
Lordship.
Something called phone also.
Lordship.
Heard Learned Counsel for the petitioner, Mr. Sarif Ahmed. Stop. Heard Learned Senior Government Advocate, Mr. Moa Imchen, appearing for respondent number. You're appearing for respondent number
Lordship,
4 and 5.
yes.
4 and 5. Stop. Mr. Moa Imchen has asked for some more time to pay the balance amount of rupees 97.50 lakhs, as the same is placed under additionality and it is yet to be released by the finance department.
No, it is with the chief minister's
So
office.
that is finance only. He is the finance minister. Yeah. It has to go to finance then
Yes.
only, by the finance department. Stop. As it has already been submitted in the affidavit of the respondent number 4 and 5, that the amount of rupees 80 lakhs is earmarked to be paid to the petitioner. The EE knockback
Yes.
is to pay the same to the petitioner within a period of, that is already available, isn't it?
That is already available.
Mm.
That is already.
Be paid to the petitioner as and when the petitioner approaches the officer concerned. Stop. The remaining amount of 97.54 lakhs shall be paid within a period of 1 month from today. Stop. This the matter.
Lordship, if the matter can be fixed on 15 May.
No. These matters, it takes time. It has to go to the finance, then from finance, it has to go to the PWD. It will take time. And additionality, it's the additional funds we are going to, the department will definitely release after 1 month only, after receiving. So
Lordship.
since I've been in the government, I know a little bit about the functioning.
Much
It's a
obliged,
matter
Lord.
after 1 month.
Lordship.
For admission, item number 3.
Lordship,
Yes.
make this your lordship.
Mm.
Your lordship here notice upon the respondent number 2.
Number
Who's
2.
the FIR complainant?
Yes.
It's completed, your lordship.
Okay, you have
However-
filed the affidavit also.
Yes, your lordship. Your lordship, however, we were informed that they are not going to engage any counsel, your lordship.
Oh, they're not going to appear.
Yes.
Okay, we'll deem it complete, the notice. Yes. PP is appearing, isn't it?
Yes, your lordship.
Who's appearing? Learned Counsel for the petitioner, MS. Second,
Vitere.
Maybe Vitere. appears for the petitioner and submits that the notice on respondent number 2 has been served by Dusty Mode, and accordingly, the affidavit has been filed. Stop. The notice on respondent number 2 is therefore deemed to be complete. Stop. Learned PP appears for the state respondents. Since the notice is complete,
Lordship, it can be taken up there and disposed of.
no, but
My-
records are not there, no?
Yes, my lord.
Oh.
One of my colleagues is appearing in this case, so let the matter will come after 1 week, my lord.
But records have to come from Hokjung
Okay.
this year.
Okay.
We have not
I
called
was
for them.
unaware of it.
No, the LCR has not been called for.
All right.
No, it hasn't come, no. Oh, it's come. It's here. But the problem is the council, no?
Yes.
Another council is appearing. So maybe after a week,
On Tuesday, perhaps, if my lord is amenable.
it's up to you.
Okay, my lord.
Mm.
Please,
Tuesday.
let
Tuesday.
inform, yes.
Deemed complete, no? So
We are all
the-
members of the same village only. We keep running into each other in churches, in social events like funeral, weddings. Yes.
there is a settlement.
Yes, there's a settlement. Yes.
The scanned copy of the trial court records have reached. So accordingly, the matter may be listed for admission hearing on 22nd.
22nd, my lord.
On 22nd April.
Deeply obliged.
Much obliged. For orders, item number 4. May I please, lordship, my lord, here I'm yet to receive scanned copy of CD. So let the matter will come up after 2 weeks, my lord.
Respondent 2 and 3 also notice. Return service reports are awaited. The office note dated 26/3/2025 indicates that return service reports are still awaited in respect of respondent number 2 and 3. Stop. The learned PP, Tipapong, also praised that he may be given some time to obtain scanned copies of the case diary. So accordingly, list the matter after
2
2
weeks.
weeks.
Yes, my lord.
After 2 weeks, awaiting service on the respondent number 2 and 3, and the learned PP shall obtain copy of the scanned copy of case diary.
Much
Oh.
obliged.
Trial court records are already here.
Okay.
Yes, it's charge sheeted.
Yes, lordship.
Charge sheeted, in that case, you don't need case diary. This will do. Yeah, it's already charge sheeted. You just delete that part. The trial court records have reached. You say await service, only that part, await service report on respondent number 2 and 3, and list the matter after 2 weeks.
Much obliged. For hearing, item number 5.
Lordship,
I was just saying
Yeah.
that I cannot take up this matter.
this matter, I have already mentioned in court number 2 because of the violation of the cost list.
Acha,
report. So I went again, I cancelled because it doesn't tally. Cost list which I have and
Yes, I believe they issued a new one again. this
okay.
morning, yes.
then we have consistently discussed to be listed on 29 of this month.
29 of this month, okay. List the matter on 29th of April. And you have to say that this matter before any other bench without me.
The interim may be continued.
The interim passed earlier shall continue till the next date.